in it. We are hopping right back in. This is part 2 today. We have our notes down here in the bottom right, what we're going through. And then we got the preview up here so I can see the chat, all that good stuff. Make sure that everything's looking good. We're going to minimize that just so that we can see. Boom. And that way we can blow up what we need to read. Like I said, we are hopping back in. This is volume 2, part 2 of my video, but volume 2 from this document, the Jack Smith report. And like I said, we are hopping right back into it. Appreciate it if you are tuning in live or if you are watching after the fact. We upload to YouTube. Actually, let me make a twit real quick to this effect. Nailed it. Can't type for shit. Let's see if I still have a... What? I don't know if that's what I want. Yeah, whatever. What was my last one? I bet I could just copy my last one. You're going to see it. You're going to see it right here, folks. This is how the sausage gets made. Copy link address. Boom. I like that better. Boom. Throw an ad in front of that. Post. Copy. Blue sky. Sorry if anybody's watching along for this part, but we gotta do the promotion. Whoa. Boom. Boom, boom, boom. Post. All right, cool. Got it everywhere. Stream's looking good. Got the viewers. Like I said, appreciate everybody who watches live. Appreciate who watches after. Let's hop right into it. Against the backdrop of that Supreme Court precedent, Congress has reenacted and indeed expanded the scope of the defraud clause, reflecting congressional ratification of the court's construction of it. See, Forest Grove, there's going to be a lot of precedent in this part. We're in the law part. This is volume 2, the law section. So what is referenced above is Congress is presumed to be aware of an administrative or judicial interpretation of a statute and to adopt that interpretation when it reenacts a statute without change. Citation and quotations omitted. In 1948, for instance, when Congress codified the general conspiracy statute, see 18 U.S.C. 371, where the defraud clause currently resides, it was already settled that, quote, settled that, quote, defrauding, end quote, the United States, quote, by depriving it of its lawful governmental functions by dishonest means is, in another quotation, defrauding, end that quotation, within the meaning of, end full quotation. The defraud clause. Glasser 315 U.S. at 66. And at that time, Congress added the words, quote, or any agency thereof, end quote, in the defraud clause after, quote, United States, end quote. The House report from the Judiciary Committee accompanying the pertinent bill specifically stated that the amendment was designed, quote, to reflect the construction placed upon the predecessor statute by the courts, end quote. And it has consistently been the department's position in litigation that the defraud clause prescribes conspiracies to obstruct a lawful function of the federal government through deceit. See gas piping for United States. Like I said, just a ton of this. And then in parentheses later on, stating petitioner's contention that defraud clause is limited to money and property schemes is, quote, inconsistent with over a century of Supreme Court precedent, end quote. See Flynn v. United States. Brief, May 19th, 2021. Stating, in parentheses again, stating defraud clause is not unconstitutionally vague in part because the Supreme Court's longstanding interpretation that interference or obstruction must be by deceit or dishonest means. And that parenthesis, Copeland v. United States, moving right along. All right. U.S., it's got all these dates. We're just going to read through this part that's referenced in the parentheses. Explaining that petitioners claim that the decisions in mail and wire fraud cases like McNally v. United States and Skilling undermine, quote, long-standing congressionally adopted construction of the defraud clause, end quote, is erroneous and misplaced and, quote, disregards important limitations inherent in the defraud clause, end quote, including the requirement to, quote, a conspiracy under the defraud clause must be deceptive and deceitful, end quote. Accordingly, the office concluded that Mr. Trump's conduct fell within the scope of Section 371 given the statute's longstanding congressionally ratified construction and its historic use by the Justice Department. The office recognized various limiting principles in the application of Section 371 that separate Mr. Trump's conduct from mere hard-scrabble politics. It's fun. A defraud clause violation, as honed by years of judicial decisions, including repeated applications by the Supreme Court, requires not only an agreement among co-conspirators, but identification of a specific function of the federal government, the intent to obstruct that function through deceit, and an overt act. See United States v. Johnson. In the parentheses for what they're referencing above, in exchange for undisclosed, quote, campaign contributions, end quote, legal fees, end quote, congressmen conspired to defeat the lawful functions of the Justice Department by urging dismissal of pending indictments. First, a defraud clause conspiracy must be targeted at a lawful function of the United States or agency thereof. See United States v. Haldeman. In quotes, the unlawful agreement to attempt to use the CIA to interfere with the investigation of the Watergate break-in was thus fairly charged in count 1 of the indictment as one of the means by which the defendants intended to accomplish one of the principal objects of their conspiracy, defrauding the United States of its right to have its officials and agencies transact their business honestly, impartially, and free from corruption or undue influence or obstruction, end quote. In contrast, a conspiracy targeted at a private party or a state or local government does not suffice, even if the entity receives federal funds or, quote, serves as an intermediary performing official functions on behalf of the federal government, end quote. Tanner, 483 U.S. at 130 and 131. Second, obstruction of the government function must be, quote, a purpose or object of the conspiracy, not merely a foreseeable consequence of the conspiratorial scheme, end quote. See United States v. Goldberg. In the parentheses for the mentioned above, emphasis in original, citing Dennis. Moving on. Thus, for example, financial crimes do not, quote, automatically become federal conspiracies to defraud the IRS, end quote, simply because the crime may have foreseeable tax implications. And this requirement means that the conspiracy must be aimed at defeating and obstructing the government function rather than simply participating in it. Third, the defraud clause, quote, is limited only to wrongs done, in another quote, by deceit, craft, or trickery, or at least by means that are dishonest, end all quote. Hammerschmidt. Fourth, the overt act requirement provides another limitation, the function of which is, quote, to manifest that the conspiracy is at work and is neither a project still resting solely in the minds of the conspirators, nor a fully completed operation no longer in existence, end quote. See Yates v. United States. Overruled on other grounds by Burke v. United States. Moving on. Finally, while a court in the District of Columbia has stated that materiality is not an element of a defraud clause conspiracy, see Concord Management and Consulting LLC, the office was prepared to move the materiality of Mr. Trump's deceptive statements and was prepared to prove the materiality of Mr. Trump's deceptive statements and to offer a materiality instruction as another limitation on the scope of Section 371. Under that limitation, even conspirators who make knowingly false statements with an obstructive intent will not violate the defraud clause unless their statements are material. All of these requirements for establishing a conspiracy to defraud under Section 371, taken collectively, ensure that common political conduct and political speech does not fall within the scope of the defraud clause. The evidence collected during the investigation met these requirements as to Mr. Trump's conduct. So this is Part B of Volume 2. Moving on. Obstruction and conspiracy to obstruct. 18 U.S.C., 1512K, and C2. The federal statute prohibiting obstruction of an official proceeding makes it a crime to, quote, corruptly, 1, alter, destroy, mutilate, or conceal a record, document, or other object, or attempt to do so with the intent to impair the object's integrity or availability for use in an official proceeding, or 2, otherwise obstruct, influence, or impede any official proceeding or attempt to do so, end quote. 18 U.S.C. 1512C. A separate provision defines the term, quote, official proceeding, end quote, to include a, quote, proceeding before the Congress, end quote. So they define that term, a proceeding before the Congress. It's quite clear. In Fisher v. United States, deciding during the pendency of Mr. Trump's immunity appeal, the Supreme Court clarified the scope of an obstruction offense under Section 1512C2, holding that the statute applies only when a defendant impairs or attempts to impair the, quote, availability or integrity for use in an official proceeding of records, documents, objects, or other things used in the proceeding, end quote. In language that applies directly to the allegations in the superseding indictment, the Supreme Court explained that Section 1512C2's criminal prohibition includes, quote, creating false evidence, end quote. Before seeking the original indictment, which, like the superseding indictment, alleged that one component of Mr. Trump's and his co-conspirators' obstruction involved replacing valid elector certificates from the contested states with false ones that they had manufactured. We're getting to the juicy bits. The office anticipated that the possibility of such a result in Fisher and confirmed that the evidence would prove Mr. Trump's guilt beyond a reasonable doubt, even under a narrow interpretation of Section 1512. My goodness. In constructing Section 1512C2 to reach impairing or attempting to impair the integrity or availability of records, documents, or other objects through, quote, creating false evidence, end quote, the Supreme Court cited United States v. Wright, in which a defendant was convicted under Section 1512 after he forged a court order and sent it in to an opposing party intending to cause that party to withdraw a mandamus petition then pending before an appellate court. Just as the defendant in Wright violated Section 1512 by, quote, injecting a false order into ongoing litigation to which he was a party, end quote, the evidence showed that the co-conspirators created fraudulent elector certificates that they intended to introduce into congressional certification proceeding on January 6th to obstruct it. The office was also prepared to prove that Mr. Trump willfully caused his supporters to obstruct and attempt to obstruct the proceeding by summoning them to Washington, D.C., and then directing them to march to the Capitol to cause the vice president and legislators to reject the legitimate certificates and instead rely on the fraudulent elector certificates. In this court case, 18 U.S.C. 2B, referenced making a defendant criminally liable for, quote, willfully causing an act to be done which, if directly performed by him or another, would be, quote, a federal offense. See United States for, I'm not going to try and pronounce that one, I apologize, HSIA. Referenced above, upholding a conviction for willfully causing a violation of 18 U.S.C. 1001. The Supreme Court's opinion in Fisher therefore did not undermine the viability of the Section 1512 counts. Much of the evidence that supports the Section 371 conspiracy to defraud likewise proves that Mr. Trump and co-conspirators violated Section 1512K and Section 1512C2 to demonstrate a violation of Section 1512C2 following Fisher. The government must prove 1. The defendant obstructed, influenced, or impeded an official proceeding or attempted to do so. 2. In the course of doing so, the defendant committed or attempted to commit an act that impaired the integrity or rendered unavailable records, documents, objects, or other things for use in the official proceeding. 3. The defendant intended to impair the integrity or render unavailable such records, documents, objects, or other things for use in an official proceeding, and the defendant acted corruptly. See United States v. Baez. Reference above, describing elements required to establish a violation of Section 1512. All the precedent in the world. Moving on. Mr. Trump's conduct establishes each of these elements beyond a reasonable doubt. The congressional certification proceeding was an official proceeding for purposes of Section 1512, as every district court judge in the District of Columbia to have considered this question has concluded, see United States v. Bringert. And as the D.C. Circuit has agreed, see Fisher, vacated, remanded on other grounds, whatever that means about that. I apologize if I don't know. The evidence described above supporting the Section 371 charge also establishes Mr. Trump's knowingly obstructive conduct. And as described above, Mr. Trump willfully caused others to attempt to obstruct the certification proceeding on January 6th. Finally, the government was prepared to prove Mr. Trump's corrupt intent under any definition beyond a reasonable doubt. To act, quote, corruptly, end quote, means 1, acting dishonestly, 2, intending the use of unlawful means, 3, violating a legal duty or causing or seeking to cause someone else to violate a legal duty, or 4, seeking an unlawful or improper benefit or advantage. Acting corruptly also means acting with consciousness of wrongdoing. See United States v. Robertson, United States v. Morrison, Arthur Anderson, LLP. Moving on. Mr. Trump and co-conspirators used deceptive and dishonest means. He intended the use of independently criminal means to obstruct the congressional certification proceeding. He and co-conspirators plainly sought to cause state and federal officials to violate a legal duty. And Mr. Trump acted, quote, with an intent to procure an unlawful benefit either for oneself or for some other person, end quote, Fisher. Most basically, Mr. Trump sought, quote, unlawfully to secure a professional advantage, in this case, the presidency, end quote. I shouldn't have added that. We'll read that back. Quote, unlawfully to secure a professional advantage, the presidency, end quote, to which he was not lawfully entitled. Volume 2, Part C. It's the third part, but Part C. Conspiracy Against Rights. 18 U.S.C. 241. Section 241 makes it unlawful for two or more persons to, quote, conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, end quote. A violation of Section 241 requires proof of three elements, which are: 1. Mr. Trump entered into a conspiracy. 2. To willfully injure, oppress, threaten, or intimidate a person in the United States. And 3. In the exercise or enjoyment of a right secured by the Constitution or federal law. 18 U.S.C. 241, see United States v. Epley. Mr. Trump's conduct meets each element. The right to vote for president based on the determination by state legislators to appoint electors based on their constituents' votes is, quote, fundamental, end quote. Bush v. Gore, 531 U.S. That would be an interesting one. We're going to scroll up here and take that, because that'll probably be worth reading up on this case. This could be a good next one to read up on. That'll be our next. I've heard some sketchy stuff about that case. It'd be fun to give it a read. So, referencing that case, we have, quote, the right to vote is the right to participate in an electoral process that is necessarily structured to maintain the integrity of a democratic system, end quote. United States v. Robinson. Section 241, quote, prohibits interference with a voter's right to cast a ballot for his or her preferred candidate and prohibits interference with the right of voters to have their votes free from dilution by unlawfully procured votes, end quote. It is a right rooted in the principles of accountability to and consent by the governed, which has distinguished this nation from its founding. Oh, my screen jumped a little bit. We're just at founding. As the Supreme Court has recognized, quote, the right to vote freely for the candidate of one's choice is of the essence of a democratic society, and any restrictions on that right strike at the heart of representative government. Do you guys remember when those idiots were saying that it's not a democracy? Like, we don't have a democracy. It's not a democracy, it's a republic. It's not a democracy, it's a republic. You remember that? I remember that. Don't let them gaslight you. Remember those 2 years, like after Biden won, where they tried to say that, what's going on right now? I'm losing my mind. Everything's backwards. That was so weird. It did T instead of V for like the longest time. What are you going to do? But yeah, those 2 years after Biden won, where they tried to say that Trump was in charge of the military and he was just like letting Biden do it for like shits and giggles. Anybody remember that? I remember that. I'm not getting gaslit out of that one. That's bullshit. Yeah, and they definitely used to say, I'm gonna write that, for repubes that say we are not a democracy. Just give multiple examples of people that disagree. That'll just be a good thing to have on hand. All right, and that was from Reynolds v. Sims. See also Yick-Wo v. Hopkins, 18 U.S. 357, 370, and 1886. where referenced voting is, quote, regarded as a fundamental political right because it is preservative of all rights, end quote. Westbury v. Sanders, 376 U.S. 1, 17, 1964. Referenced, quote, no right is more precious in a free country than that of having a voice in the election of those who make the laws under which, as good citizens, we must live. Other rights, even the most basic, are illusory if the right to vote is undermined. My goodness. Back when we used to get good fucking decisions. You guys remember that? I remember that. What is happening right now? I think my computer is gaslighting me. We might be able to paste later. We'll see. Mr. Trump acknowledged that voting in a presidential election is a fundamental right under the Constitution. See ECF number 163 at 23, arguing that, quote, urging states or Congress to use their power to select or to count electors does not affect the fundamental, in quotes, right to vote because it does not arbitrarily, quote, value one person's vote over that of another, end quote, Bush, or restrict the exercise of that right. Rather, it encourages the states and Congress to exercise their constitutional prerogatives a certain way, end quote. Indeed, given that all states have made the popular vote an integral means of appointing electors, the right to vote in a presidential election is among the most precious federal rights protected by the Constitution. See United States v. Classic, 1941. When a state makes a primary election, quote, an integral part of the procedure for the popular choice of a congressman, end quote, it becomes, quote, a right established and guaranteed by the Constitution, end quote. See also Trump v. Anderson, bunch of stuff. Reference, noting the, quote, uniquely important national interest, end quote, in, quote, a presidential election, end quote, because the, quote, president represents all the voters in the nation, end quote. So there's a higher bit of importance because it's the president. Lols. That's why it's so important. That's why it's so dog shit that you guys are so dog shit. It's kind of dog shit. Wish you guys weren't so trash. I don't know what the fuck is going on with my keyboard and shit. Sometimes shit's working, sometimes shit's not. Hopping right back in, right here. This history of the Section 241 offense with which Mr. Trump was charged, along with courts' universal and longstanding recognition of the voting rights protected by that statute, confirm that protecting the right to vote is critical to the existence of the right. Section 241's predecessor statute was passed as part of the Enforcement Act of 1870, a Reconstruction-era law to address the, quote, continued denial of rights, end quote, to black citizens, quote, sometimes accompanied by violent assaults, end quote. See United States v. Price, 383 U.S., 787, 801 to 802, 1966. The act sought to combat widespread anti-Reconstruction violence, which included acts of terror aimed at disenfranchising black voters. The same year as the act's passage, Congress established the U.S. Department of Justice, and the department zealously pursued its mission to enforce voting rights in the Reconstruction era. Though the application and interpretation of Section 241 and its predecessor statute, courts have repeatedly underscored the importance. Sorry, that was misread from the start. Through the application and interpretation of Section 241 and its predecessor statute, courts have repeatedly underscored the importance of the right to vote. Courts have held that the right encompasses the ability to cast a vote, ex parte Yarba, the Ku Klux cases, 110 U.S. 651, 657, 658, 1884, referenced protecting right of an emancipated person to vote and to have that vote counted. United States v. Mosley, referenced, quote, We regard it as equally unquestionable that the right to have one's vote counted is as open to protection by Congress as the right to put a ballot in a box, end quote. They have further confirmed that one's vote cannot lawfully be denied, destroyed, or diluted. See Classic 313, U.S. 321, 322 referenced, holding that Section 241's predecessor statute applied to conspiracies to prevent the official counting of ballots in a primary election, United States v. Saylor, reference, Section 241 applies to prohibit conspiracies to dilute legitimate votes by stuffing the ballot box. United States v. Pleva, 2nd District Circuit, 1933, referenced, Board of Elections inspectors charged with falsely tabulating ballots to favor certain candidates, convictions reversed on separate jury grounds. United States v. Skurla, reference, defendants charged for casting and causing to be cast false and forged ballots, causing incorrect vote tally, and using unqualified individuals to impersonate lawful voters. United States v. Townsley, scheme to discard certain absentee ballots. Moving on. Mr. Trump and co-conspirators sought to deprive, that is, injure or oppress, citizens of their constitutional right to have their presidential election votes counted. The words, quote, injure or oppress, end quote, in Section 241 are not used in any technical sense, but cover a variety of conduct intended to prevent, harm, inhibit, hinder, frustrate, obstruct, or interfere with the free exercise and enjoyment of a right. See United States v. Handy, see United States v. Mackey. Although they were not in a back room altering the vote tallies in a local election or stuffing falsified ballots into ballot boxes as alleged in prior cases charged under this statute, Mr. Trump and his co-conspirators nonetheless sought the same result: to effectively cast aside legitimate votes in a manner that would have deprived citizens of their right to vote and have their votes counted. As co-conspirator one, Rudy Giuliani, admitted, their primary objective was to, quote, just flat out change the vote, deduct that number of votes from the declare those votes, 300,000 votes in Philadelphia, illegal, unlawful, reduce the number by 300,000, end quote. Holy boy, Jesus. Yeah, we're going to get that one. We're going to make sure we get that one. Boom. Mr. Trump attempted to carry out this objective in multiple ways. He urged state officials to disregard the legitimate majority of votes for Mr. Biden and pressured and threatened Georgia's state Secretary of State to, quote, find, end quote, more than 11,000 votes to dilute Mr. Biden's vote count in the state. And he urged Mr. Pence to discard legitimate electoral certificates that reflected millions of citizens' votes in the targeted states. The evidence collected showed that Mr. Trump targeted his vote counting right with precision. He centered his false claims of election fraud on select states or cities and counties within those states with large numbers of voters who had not chosen to reelect him. So we're going to reread that one again. The people he was targeting. The evidence collected showed that Mr. Trump targeted this voting right with precision. He centered his false claims of election fraud on select states or cities and counties within those states with large numbers of voters who had not chosen to reelect him. Moving on to Part D. That was the last time. We make sure we hit it hard for the last part. So this is Part D of Volume 2. Defenses. Before presenting the original indictment to grand jury, the office considered Mr. Trump's potential defenses to these charges, including a good faith defense, an advice of counsel defense, and constitutional defenses. The office concluded that each of the defenses was legally or factually flawed and thus would not prevail. First, it was expected that Mr. Trump would argue that he acted in good faith when he sought to stop the transfer of presidential power because he genuinely believed that the outcome-determinative fraud had undermined the election's integrity and caused him to lose. As set forth above in Section 2A, Oh, that was the one right above. I don't know why that threw me for a loop. The office developed strong proof that Mr. Trump knew that his election fraud claims were false. For example, Mr. Trump made persistent claims of large numbers of dead voters in Georgia, including in his speech at the Ellipse on January 6th. Even though his senior campaign advisor and Georgia's Secretary of State had told him that the claims were untrue, he spread lies, including in his Ellipse speech, of sinister, fraudulent, quote, vote dumps, end quote, in Michigan, even after Michigan's Senate Majority Leader told him there was nothing suspicious had occurred, that nothing suspicious had occurred. My goodness. You just love when it's laid out. You love when you get to the juicy bits. Let me take a sip. Right up in the juicy bits. And Mr. Trump repeatedly made provably false allegations about fraud in Pennsylvania, despite having been told by the chairman of the state Republican Party that the vote count was occurring as expected. It's just like so many different people, too. It's like the Secretary of State, the Senate Majority Leader, the chairman of the state Republican Party. Like, your people are telling you it's over, and you're just, nope, like, absolutely not. Even if Mr. Trump maintained that he sincerely believed he won the election, a conclusion unsupported by the evidence collected in the investigation, it would not provide a defense to the Section 371 charge. A defendant may not use deceit to obstruct a government function even if he believes the function itself to be unconstitutional because a claim of unconstitutionality, to be unconstitutional because, quote, a claim of unconstitutionality will not be heard to excuse a voluntary, deliberate, and calculated course of fraud and deceit, end quote, Dennis. 384 U.S. at 867. Quote, one who elects such a course as a means of self-help may not escape the consequences by urging that his conduct be excused because the statute which he sought to evade is unconstitutional, end quote. There are, quote, appropriate and inappropriate ways to challenge, end quote, perceived illegalities. Just as the president of a company may be guilty of fraud for using knowingly false statements of fact to defraud investors, even if he subjectively believes that his company will eventually succeed. See United States v. Arif. And also United States v. Kennedy, also United States v. Chavez? Chavi? I'm not sure. I apologize. Mr. Trump could be convicted of using deceit to obstruct the government function by which the results of the presidential election are collected, counted, and certified, even if he established that he subjectively believed that he had reason to do so because of his claims that the election was, quote, rigged, end quote. It bears emphasis that Mr. Trump's knowing deceit was pervasive throughout the charged conspiracies. This was not a case in which Mr. Trump merely misstated a fact or two in a handful of isolated instances. On a repeated basis, he and co-conspirators used specific and knowingly false claims of election fraud in his calls and meetings with state officials in an effort to induce them to overturn the results of the election in their states. To his own vice president to induce Mr. Pence to violate his duty during the congressional certification proceeding, and on January 6th as a call to action to the angry crowd he had gathered at the Ellipse and sent to the Capitol to disrupt the certification proceeding. Mr. Trump and co-conspirators used other forms of deceit as well, including when they falsely represented that the fraudulent electoral votes would be used only if Mr. Trump prevailed in pending contests in their states, and when they caused the fraudulent electors to falsely swear that they were duly certified and send those false certifications to Congress. Regardless of any claim that Mr. Trump subjectively believed the outcome of the election was unfair or, quote, rigged, end quote, the office concluded that these knowingly deceitful statements and acts would overcome any good faith defense. The office also expected that Mr. Trump might claim that his consultation with attorneys, several of whom were co-conspirators, should negate a finding that he acted with a criminal state of mind. This is the wild one. Like, can you just break the law? The Better Call Saul. Can you just break the law if you just tell your lawyer you want to break the law? In pretrial litigation, the court granted the government's motion that Mr. Trump should be required to declare whether he intended to employ such a defense and, if he did, to produce the discovery required by the attendant waiver of Mr. Trump's attorney-client privilege, ECF number 147. A defendant's claim that he relied in good faith on his attorney's advice is, quote, not an affirmative defense that defeats liability even if the jury accepts the government's allegations as true, end quote, but functions instead as, quote, evidence that, if believed, can raise a reasonable doubt in the minds of the jurors about whether the government has proved the required element of the offense that the defendant had, in another quote, unlawful intent, end all quote. United States v. Scully, United States v. Beechnut Nutrition Corp. Under D.C. Circuit law, an advice of counsel defense consists of two elements. The defendant, one, quote, relied in good faith on the counsel's advice that his course of conduct was legal, end quote, and two, quote, made full disclosure of all material facts to his attorney before receiving the advice at issue, end quote. See United States v. Gary Burris, United States v. DeFries. The office concluded that Mr. Trump, hold on, let's back up. There we go, right there. The office concluded that if Mr. Trump chose to raise such a defense, it would fail because of an advice of counsel defense is not available, quote, where counsel acts as an accomplice to the crime, end quote. United States v. West. The evidence showed that the central attorneys on whom Mr. Trump may have relied for such a defense, such as Rudy Giuliani, and I believe that's Powell, we have him written down up here. Nope, Eastman. Such as Rudy Giuliani and John Eastman were, quote, partners in a venture, end quote, with the result that any advice of counsel defense necessarily would fail. Citing United States v. Carr, United States v. Sintolo, quoting, a criminal lawyer has no license to act as a lawyer criminal, end quote. Whoever wrote that, that's a bar. That's an absolute bar. Co-conspirator one, also known as Rudy Giuliani, assisted Mr. Trump in using knowingly false claims of election fraud in furtherance of the charged conspiracies. At press conferences, at hearings before legislatures in the targeted states, and directly with the officials in the targeted states, Rudy Giuliani made a wide range of specific, though ever-changing, false claims of election fraud. Co-conspirator one, Rudy Giuliani, continued to do so after his lies were publicly or directly debunked. He then went on, his involvement spanned from his insistence that Mr. Trump declare victory on election night to the voicemails that Rudy Giuliani left for senators on the night of January 6th, using false claims of election fraud to ask that the legislators further delay the certification. John Eastman was instrumental in Mr. Trump's efforts to organize his electors to cast fraudulent votes and send them to the vice president, and then to pressure the vice president to use fraudulent electoral certificates to overturn the election results. Throughout his involvement in Mr. Trump's conspiracies, John Eastman conceded privately to other attorneys, both private attorneys and those responsible for advising Mr. Trump and the president, that his plans violated federal law and would not withstand scrutiny in court. Dagger to the heart. Your lawyer knows you're fucked, and said it to a friend. Furthermore, Mr. Trump could not have succeeded in showing that he relied in good faith on legal advice from these attorneys. The evidence showed that Mr. Trump was not looking to Rudy Giuliani or John Eastman for legal advice. Instead, Mr. Trump was the head of a conspiracy who sought legal cover from his conspirators. As Rudy Giuliani acted repeatedly in furtherance of the conspiracies, multiple advisors to Mr. Trump warned him that Rudy Giuliani would not successfully challenge the election results and was not acting in Mr. Trump's best interest. Mr. Trump ignored them all because he was not relying on Rudy Giuliani as an attorney. Similarly, John Eastman's willingness to advocate for actions that he knew and even privately conceded were unlawful demonstrates that both he and Mr. Trump understood his role was not that of an attorney offering legal advice on which Mr. Trump was acting. For instance, in a lawsuit in Georgia, John Eastman filed a false certification by Mr. Trump after having written to other attorneys in an email that both he and Trump knew some of the allegations incorporated in the filing were inaccurate. And John Eastman's decisions to advocate to the Vice President's counsel and Chief of Staff on January 5th, 2021, that the Vice President should unlawfully reject legitimate electoral certificates, an act that John Eastman had previously recognized would not be supported by the Constitution or federal law, was a sharp reversal from his position just one day earlier and happened only because Mr. Trump made clear that it was his preferred strategy. The office was otherwise confident that it would be able to demonstrate that with respect to all attorneys, Mr. Trump could not meet the elements of the defense, such as the requirements that he make full disclosure to any attorneys of all relevant facts and then rely faithfully on their advice. See, get your Gray Burris. I said Gary Burris earlier. It's Gray Burris, at least right here. Finally, the office anticipated that Mr. Trump would claim that his conduct was protected by the First Amendment. As the district court recognized, quote, the First Amendment, in another quote, embodies our profound national commitment to free exchange of ideas, end all quote. And it bars the government from, quote, restricting expression because of its message, its ideas, its subject matter, or its content, end quote. Quoting Ashcroft v. blah, 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 blah. I'm going to have to read up on all this stuff one day. United States v. Stevens, a bunch of other stuff. At the same time, quote, it is well established that the First Amendment does not protect speech that is used as an instrument of a crime, end quote. Quote, many long-established criminal laws permissibly, quote, criminalize speech that is intended to induce or commence illegal activities, end all quote. I think. See United States v. Williams, such as fraud, bribery, perjury, extortion, threats, incitement, solicitation, perjury, blackmail, because I fucked up perjury when I said it before. And then it lists all the ones, a bunch of stuff. If you want to see that, go somewhere else. I'm just starting from this quote. Quote, prosecutions for conspiring, directing, and aiding and abetting do not run afoul of the Constitution when these offenses are, quote, carried out through speech, end all quote. Quoting National Organization for Women versus Operation Rescue, citing Williams, District Court, 1994. Consistent with that precedent, the original and superseding indictments recognize that Mr. Trump, quote, had a right, like every American, to speak publicly about the 2020 presidential election and even claim falsely that there had been outcome-determinative voter fraud during the election that he had won, and that he had won. They charged Mr. Trump, however, with using knowingly false statements to defeat a government function, injure the right to vote, and obstruct an official proceeding. That is, he made, quote, dozens of specific claims that there had been substantial fraud in certain states, such as the large numbers of dead, non-resident, non-citizen, or otherwise ineligible voters had cast ballots, or that voting machines had changed votes for the defendant to votes for Biden. Those were factual claims that were verifiably false, and Mr. Trump knew that they were false. Mr. Trump then used those lies as instruments of his 4 criminal offenses. Sorry, it just geeks me sometimes. We are doing this January 20th, just for the record. It's a great time. January 20th, 2025, for whatever that means to the aliens that are watching this afterwards. Shit got wild down here. Shit got wild. Because he used those knowingly false statements regarding specific facts to commit these crimes charged in the superseding indictment, they were not protected by the First Amendment. See Stevens, including, quote, fraud, end quote, in the list of, quote, well-defined and narrow limited cases of speech, the prevention and punishment of which has never been thought to raise any constitutional problem, end quote. United States v. Nordine, quote, by focusing on, quote, corrupt, end quote, actions, does not even reach free speech. Nice. United States v. Alvarez. Plurality opinion, explaining that while, quote, falsity alone may not suffice to bring the speech outside the First Amendment, end quote, the First Amendment permits criminal laws that prescribe knowing and reckless falsehoods in connection with some, quote, other legally cognizable harm, end quote, including, quote, protecting the integrity of government processes, end quote. Sounds like a cut and dry explanation to me. In pretrial motions, Mr. Trump moved to dismiss the original indictment based on the First Amendment. The office filed an opposition brief, and the district court denied the motion, finding that the indictment, quote, properly alleges defendant's statements were made in furtherance of a criminal scheme, end quote. As the court explained, Mr. Trump was, quote, not being prosecuted for his, quote, view, end quote, on a political dispute. He was being prosecuted for acts constituting criminal conspiracy and obstruction of the electoral process. And the fact that his, quote, alleged criminal conduct involved speech does not render the indictment unconstitutional, end quote. Just because he said it doesn't mean it's not freedom of speech. Like, oh, you say it out loud, it's okay. Oh, I got it out loud. Because he was, quote, not being prosecuted for simply making false statements, but rather for knowingly making false statements in furtherance of a criminal conspiracy and obstructing the electoral process, quote, there was, quote, no danger of a slippery slope in which inadvertent false statements alone are alleged to be the basis for criminal prosecution, end quote. And this is rejecting the First Amendment claims. And this is part E of volume 2. Other charges. The office considered, but ultimately opted against, bringing other charges. One potential charge was 18 U.S.C. 2383, sometimes referred to as the Insurrection Act, which provides, quote, whoever incites, sets foot, assists, or engages in any rebellion or insurrection against the authority of the United States or the laws thereof, or gives aid or comfort thereto, shall be fined under this title or imprisoned not more than 10 years or both, and shall be incapable of holding any office under the United States. We're going to give that a little control copy. Get that down here. Originated during the Civil War as part of the Second Confiscation Act of 1862. Cases interpreting Section 2383 are scarce and arose in contexts that provided little guidance regarding its potential application in this case. See United States v. Greathouse. Referenced, construing the original version of the act to encompass treason, consisting of arming a vessel to commit hostilities against United States vessels in the context of a rebellion by the Confederate States. United States v. Cathcart. Referenced, rejecting legal argument that treason against the United States was legally impossible in the context of the rebellion by the Confederate States. In grand jury, reference grand jury charge describing offense in the context of a labor dispute involving interference with transportation of the mail. Can't fuck with the mail. Same grand jury charge that, quote, insurrection is a rising against civil or political authority, end quote, and requires, I don't know if I got the quote to start on that one, but end quote, and requires, quote, such a number of persons as would constitute a general uprising in that particular locality, end quote, in the context of offense of obstructing the mails. It does not appear that any defendant has been charged with violating the statute in more than 100 years. To establish a violation of Section 2383, the office would first have to prove that the violence at the Capitol on January 6, 2021 constituted an, quote, insurrection against the authority of the United States or the laws thereof, end quote, and then prove that Mr. Trump, quote, incited, end quote, incited, end quote, or, quote, assisted, end quote, the insurrection or, quote, gave aid or comfort thereto, end quote, 18 U.S.C. 2383. Courts have found or described the attack on the Capitol as an insurrection. In Anderson v. Griswold, revved on other grounds by Trump v. Anderson, the Colorado Supreme Court found that Mr. Trump engaged in an insurrection as that term is used in Section 3 of the 14th Amendment. Federal courts in the District of Columbia have also used the term, quote, insurrection, end quote, to describe the Capitol attack, to describe the attack on the Capitol, but did so in cases where there was no criminal charge under Section 2383. So they called it that, but they didn't charge that. So he's explaining why he didn't. For all these arguments, it's crazy. Like, I've heard multiple people argue this, and it's just so clear that no one, at least the people that made those arguments, no one went through and read this. It's such a fucking dagger. But if you're watching along, really appreciate you. Or if you're watching after, really appreciate you. So D.C. District Court, April 19th, 2023, United States v. Cheswick. Quote, as this court and other courts in the United States District Court for the District of Columbia have stated previously, what occurred on January 6, 2021 was in fact an insurrection and involved insurrectionists, and therefore the terms to which defendants object are accurate descriptors, end quote. United States v. Carpenter, D.C. District Court. I don't know if that's what DDC, February 9th, 2023. Quote, what occurred on January 6th was in fact a riot and an insurrection, and it did in fact involve a mob, end quote. It's got all of them. See also United States v. Munchell, using the term, quote, insurrection, end quote, in a case that did not involve Section 2383. So it's been used before. These cases, however, did not require the courts to resolve the issue of how to define insurrection for purposes of Section 238 exactly, or apply that definition to the code or the conduct of a criminal defendant in the context of January 6th. The office recognized why courts describe the attack on the Capitol as an insurrection, in quotes, but it was also aware of the litigation risk that would be presented by employing this long dormant statute. As to the first element under Section 2383, proving an, quote, insurrection against the authority of the United States or the laws thereof, end quote, the cases the office reviewed provided no guidance on what proof would be required to establish an insurrection or to distinguish an insurrection from a riot. Generally speaking, an, quote, insurrection is a rising against civil or political authority, the open and active opposition of a number of persons to the execution of law in a city or state, end quote. See also insurrection, Merriam-Webster, quote, an act or instance of revolting against civil authority or an established government, end quote. American Heritage Dictionary, they're just giving you everything. Quote, to act or an instance of open revolt against civil authority or a constituted government, end quote. The Oxford English Dictionary, quote, the action of rising in arms or open resistance against established authority or governmental restraint. So it doesn't have to have weapons, dipshits, to everybody who said they didn't have guns, so it's not an insurrection. You're a fucking idiot. Because this one thing said so. The Oxford Dictionary said so I'm right about everything. Suck it. Some sources distinguish an insurrection, quote, from a rout, riot, or offense. My goodness, I'm missing all the quotes. From a, quote, rout, riot, or offense connected with mob violence by the fact that an insurrection there is an organized and armed uprising against authority or operations of government, while crimes growing out of mob violence, however serious they may be, and however numerous the participants are simply unlawful acts and disturbance of the peace which do not threaten the stability of government and the existence of political society. Black Laws Dictionary. That's an interesting one. It feels like it makes a little space for the mafia in there. Maybe I'm crazy. Maybe I'm just reading it, going crazy, just reading too much. Eyes going together. So Black Law Dictionary, see also Anderson, noting Mr. Trump's argument that, quote, an insurrection is more than a riot, but less than a rebellion, end quote, and agreeing that, quote, an insurrection falls along a spectrum of related conduct, end quote. In case law interpreting, quote, insurrection, end quote, in another context, one court has observed that an insurrection typically involves overthrowing a sitting government rather than maintaining power, which could pose another challenge to proving that Mr. Trump's
Emalia of Tuber 12
January
just
6th
followed.
qualified as
Welcome
an
to the
insurrection
Far
given
King Show.
That he was the sitting president at the time. Welcome. Thanks for the follow. Citgo Petroleum Corp v. Starstone Institute got a whole bunch of case precedent there, but it's referencing this here below. In quotes, in every case over the course of over 60 years to find the evidence of an insurrection within the meaning of an insurance policy, the insurrection has occurred against, not by, the established, effective, and de facto government, end quote. Pan Am World Airways Inc. versus Aetna, referencing, quote, the district court held that the word insurrection means 1, a violent uprising by a group or movement, 2, acting for the specific purpose of overthrowing the constituted government and seizing its powers, end quote. Court got more case law, First Court, 1954, noting that if Puerto Rican extremists had a, quote, maximum. Yeah, I'll follow you on Twitter. When I hop off here, I got you, bud. I see you in the chat. I appreciate you. I'll finish up here and then I got you. Puerto Rican extremists had a, quote, maximum objective, end quote, to, quote, overthrow the insular government, quote, on the island. That group's uprising would constitute insurrection. Hartford Fire Insurance versus Western Union Company. Referencing a Russian-backed separatist group's attack on a plane in service of overthrowing the current government in eastern Ukraine was an insurrectionary act. Boom, 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 more stuff. All defining insurrection. But here we go. Cigna versus Unis Bros versus Cigna Worldwide, applying Davila in finding that where individuals outside of the libertarian government, quote, led their respective armies in a violent uprising, end quote, quote, against the Liberian government, that was a close one, end quote, damage to properties fell within insurance contracts insurrection clause. The office did not find any case in which criminal defendant was charged with insurrection for acting within the government to maintain power, as opposed to overthrowing it or thwarting it from the outside. Applying Section 2383 in this way would have been a first, which further weighed against charging it, given the other available charges, even if there were reasonable arguments that it might apply. So they decided not to do this because they had other charges to do, and it would have been the very first time charging it this way, and they cited all these things where it's a self-coup. He was the president at the time, and then he tried to coup his own government. So that's why it's one of those things that complicates it. It's why it makes these issues so complex. That's why I got to read through. As the second element under Section 2383, there does not appear to have ever been a prosecution under the statute for inciting, assisting, or giving aid or comfort to rebellion or insurrection. The few relevant cases that exist appear to be based on a defendant directly engaging in rebellion or insurrection, but the office's proof did not include evidence that Mr. Trump directly engaged in insurrection himself. Thus, however strong the proof that he incited or gave aid and comfort to those who attacked the Capitol, application of those theories of liability would also have been a first. See Alexander Tessa's incitement to insurrection and the First Amendment, wake for blah, 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 blah. And the quote is, the likelihood of conviction under the federal incitement of insurrection statute, 18 U.S.C. 2383, is fraught with uncertainty because no federal court has interpreted it, end quote. So you don't put something in if you're not 100% sure it's going to go your way, is what they're saying here. So they just went with the ironclad case over the bullshit, and then people still argue over the bullshit. It's kind of silly. The office determined that there were reasonable arguments to be made that Mr. Trump's ellipse speech incited the violence at the Capitol on January 6th and could satisfy the Supreme Court standard for, quote, incitement, end quote, under Brandenburg v. Ohio. Referenced, holding that the First Amendment does not protect advocacy, quote, directed to inciting or producing imminent lawless action and likely to incite or produce such action, end quote. Particularly when the speech is viewed in the context of Mr. Trump's lengthy and deceitful voter fraud narrative that came before it. For example, the evidence established that the violence was foreseeable to Mr. Trump, that he caused it, that it was beneficial to his plan to interfere with the certification, and that when it occurred, he made a conscious choice not to stop it and instead to leverage it for more delay. But the office did not develop direct evidence, such as an explicit admission or communication with co-conspirators, or Mr. Trump's subjective intent to cause the full scope of the violence that occurred on January 6th. So they didn't have direct there, so they didn't want to do that because, like I said, you want to have an ironclad case. Therefore, in light of the powerful charges available, and because the office recognized that the Brandenburg Standard is a rigorous one, see NAACP versus Claiborne Hardware, speech delivered in a, quote, passionate atmosphere, end quote, that referenced, quote, possibility that necks would be broken, end quote, and violators of boycott would be, quote, disciplined, end quote, did not satisfy the Brandenburg standard. Reversing conviction where Ku Klux Klan leader threatened, quote, revengeance, end quote, for, quote, suppression, quote, of the white race, it concluded that pursuing an incitement to insurrection charge was unnecessary. By comparison, the statutes that the office did charge had been interpreted and analyzed in various conducts over many years. The office had a solid basis for using sections 371, 1512, and 241 to address the conduct presented in the case, and it concluded that introducing relatively untested legal theories surrounding section 2383 would create unwarranted litigation risk. So don't take the chance. Take the ironclad one in. Importantly, the charges the office brought fully addressed Mr. Trump's criminal conduct, and pursuing a charge under section 2383 would not have added to or otherwise strengthen the office's evidentiary presentation at trial. For all of these reasons, the office elected not to pursue charges under section 2383. So they didn't think they had it ironclad. All right, so we are almost to volume 3, which might be a good stopping point. We'll see where we are there. I've been streaming for about an hour. I do have one thing I got to get to tonight, but we will at least get through the law section. This will be part 2, and then part 3 is coming, and then we'll take a look at what we have ahead. Co-conspirator liability. This is volume 2, part F. As described in the factual recitation above, Mr. Trump was charged with participating in crimes with at least 6 co-conspirators, and the office's investigation uncovered evidence that some individuals shared criminal culpability with Mr. Trump. Following the original indictment on August 1st, 2023, the office continued to investigate whether any other participant in the conspiracies should be charged with crimes. In addition, the office referred to a United States Attorney's Office for further investigation evidence that an investigative subject may have committed unrelated crimes. Before the department concluded that this case must be dismissed, the office had made a preliminary determination that the admissible evidence could justify seeking charges against certain co-conspirators. The office had also begun to evaluate how to proceed, including whether any potential charged case should be joined with Mr. Trump's or brought separately. Because the office reached no final conclusions and did not seek indictments against anyone other than Mr. Trump, the head of the criminal conspiracies and their intended beneficiary, this report does not elaborate further on the investigation and preliminary assessment of uncharged individuals. This report should not be read to allege that any particular person other than Mr. Trump committed a crime, nor should it be read to exonerate any particular person. Ain't that some shit? All right, and then this is volume 3, where we will rip through just gonna cheat down to the end. Where's the actual? I appreciate all this due diligence. I really do. 137 is where we actually are. Boom. Let's just read through the conclusion. Let's get a peek up at the bottom here, just to end section 2. Just to make sure we have it out. It's an important day, so I'd say we read through this and then we get it out. I will be going back through it. The show must go on. We demand a part 3. We get a part 3. That's how it goes. I'm a slow reader, apparently, so we're going to go through all section 3. I'll talk about that. We'll go back up to the table of contents, and we'll talk about volume 3. We'll pull all this together from my notes, and then we'll get this into something workable, so we have these spread out in arguments. And then if anybody would like to have any conversations on any of this stuff, if you think this is all bullshit, if you think you have something to say about it, please, I would love to talk to you about this. This stuff is driving me crazy. Just, talking to myself about it. So would love to bounce it off somebody. So if you really need to talk, feel free to shoot out one of the many places. We could stream, we could do some Discord, all the million things. Let's rip through the conclusion here, skipping ahead, getting to the juicy bits at the end, and then we will hop back in for the rest of it next time. Skipping over volume 3 to volume 4 so that we can get a good juicy end to this one. Not ending on what they didn't charge with. This will give us a good read to end the stream on. Volume 4, conclusion. On remand of the Supreme Court's decision in Trump, the district court set a litigation schedule whereby the parties would submit briefs regarding whether any material in the superseding indictment was subject to presidential immunity. The parties were in the middle of that process when the results of the presidential election made clear that Mr. Trump would be inaugurated as President of the United States on January 20th, 2025. Today. I'm so glad we skipped down to this. Isn't it so? How did I know? As described above, it has long been the department's interpretation of that the Constitution forbids the federal indictment and prosecution of a sitting president. But the election results raised for the first time the question of the lawful course when a private citizen who has already been indicted is then elected president. The department determined that the case must be dismissed without prejudice before Mr. Trump takes office, and the office therefore moved to dismiss the indictment on November 25th, 2024. The district court granted the motion the same day. The department's view that the Constitution prohibits the continued indictment and prosecution of a president is categorical and does not turn on the gravity. What am I saying? I can't even read. We're starting that paragraph over again. The department's view that the Constitution prohibits the continued indictment and prosecution of a president is categorical and does not turn on the gravity of the crimes charged, the strength of the government's proof, or the merits of the prosecution, which the office stands fully behind. Indeed, but for Mr. Trump's election and imminent return to the presidency, the office assessed that the admissible evidence was sufficient to obtain and sustain a conviction at trial. We're going to read that one again. Indeed, but for Mr. Trump's election and imminent return to the presidency, the office assessed that the admissible evidence was sufficient to obtain and sustain a conviction at trial.